in the next moment or so. But in the meantime, thank you very much for attending this afternoon's session. For those that don't know me, I'm Antonio Fletcher. I'm head of the employment team here at Whitehead Monkton, and I'm joined by one of the solicitors in our team, Lydia Ashman, and we will be taking a bit of a whistle-stop tour because of the volume of proposed changes around Labour's first 75 days in government and what that means for employment law in the UK. So I will move on now. So in essence, so we're 75 days on exactly from the general election. Lots of talk pre-election and since about what Labour are planning to do and will do in the next 100 days. Sorry, in the first 100 days from taking power. So now seems a good time to review progress. It's certainly clear that there are going to be extensive changes to the current laws and the current landscape in some respects as well, in terms of the process behind employment mechanisms and the employment tribunals themselves. But what are those changes, and what are they likely to mean for employers and employees? That's what we'll be seeking to understand today. We've broken this down into sort of half a dozen sections. Looking firstly, Lydia will look at the impact of day one unfair dismissal rights, ending 0 hours contracts, and the rights to disconnect, as it's become known. And then I will take us through a few more elements, so the changes to flexible working and family-friendly rights that are potentially in the pipeline, the new sexual harassment laws that, out of everything, are the most concrete change that is very shortly going to be upon us. Changes to sick pay, ending fire and rehire, again as that's known, and then also looking at a few other elements at the end of the session that are in the pipeline. And in respect of each of those policies, each of those topics, we're going to break it down and consider what does the current law say, what are the proposed changes that are in the pipeline. What does this mean for employers and employees, and as an employer, what you can start doing now to get ready. So I will hand over to Lydia now for this first section, talking about the impact of day one unfair dismissal rights.
Hello. So as you can see from the slide, the current law on unfair dismissal is that employees can only obtain unfair dismissal rights when they reach 2 years qualifying service with their employer. But there are, of course, some exceptions to that rule. For example, dismissals that are the result of that are discriminatory in nature or as a consequence of whistleblowing. So workers can therefore only be dismissed for one of the 5 fair reasons that are set out in current legislation. Some of you may recall that protection from unfair dismissal was actually increased from 1 year's qualifying service to 2 years back in 2012 by the coalition government. And since then, it has not been changed. The protection for unfair dismissal has not been changed since then. But obviously, the new government is proposing quite a significant change in this qualifying period, and they're actually looking for it to be removed and that protection from unfair dismissal become a day one right. The government has said that in their plan to make work pay, the changes won't prevent employers from making fair dismissals for reasons of redundancy, capability and conduct, which are 3 of the 5 fair reasons currently in place. But they've also stated that dismissals will also be fair under probationary periods with fair and transparent rules and processes. They've also said that the changes to ensure that newly hired workers are not fired without fair reason or cause, in a bid to ensure that there are those protections there for them, but also to help drive up standards in the workplace so that employers can't just dismiss someone because they may, for example, may not fit the mould. What this could look like, we do not know specifically. Obviously, we've just got a general idea as to what this could be. But it's looking likely that the 2-year qualifying period will need to be removed from the Employment Rights Act, which would then mean that employers will need to ensure that any dismissals going forward will fall within one of the 5 fair reasons and that they've acted reasonably in the circumstances leading up to the termination of the employment. It's also been made clear by the government that there will be a greater focus on probationary periods, but again, we don't know specifically how they will be addressed, whether this is through legislation, ACAS guidance or codes of practice, or a combination of both. There are questions that still remain around whether dismissals will be considered fair if done during the probationary period, or if failing probation will also be a fair reason for the dismissal. But it's expected that whatever changes the government propose, whether that's legislative or codes of practice, will address those questions. We also think that the legislation will be introduced specifically to deal with dismissals during the probationary periods, rather than everything all just being in one place. So the code of practice is likely to then deal with appropriate processes to follow during any probationary period. So that's why it's looking likely a combination of the two. So the legislation will set out what will actually happen for dismissals, but then there's a code of practice to give the guidance alongside it and for processes and procedures that may be followed during that time. Regardless, there is with the changes that's being made, employers really should take this as an opportunity to review any policies and procedures that they have in place, but actually also to look at employment contracts themselves too, because a lot of employers will have probationary periods set out in contractual terms rather than in a separate policy and procedure. There's also the chance that many employers will not have looked too carefully at their probationary periods since the change was made 2 years ago, back in 2012, sorry, when the increase was from 1 year to 2 year for unfair dismissal protection. So this actually, anyway, is a good opportunity for employers to take to have a look at any changes that may be coming in, but also to look at their own policies to see if there's anything that can be done now. It also means as well, if you start taking a look at potential gaps in any policies that you may have and in your contract, it gives you an opportunity to work out what changes may be needed and to tighten up some gaps that you may have. But it also means that actually you're taking the chance to have a look at probationary periods across all levels across your workforce, rather than those that are just coming in at maybe entry or junior level places. You need to remember that most people have probationary periods across the whole range of staff. There's also the chance that with the change to unfair dismissal rights, we'll also see an impact on the employment tribunals, and ACAS as well will be heavily impacted by this. The number of employment tribunal claims is back up to pre-pandemic levels, and at the end of 2024 there are 440,000 open employment tribunal cases. So by reducing the qualifying period for unfair dismissal, we may see that actually there will be an increase in claims because employees won't have to wait as long to bring a claim, or may not even have to, or will just be able to bring a claim for unfair dismissal without needing to think of other heads of claim that can go alongside that. So this will undoubtedly have a negative impact on the courts and ACAS if careful consideration isn't given to probation periods going forward, and how employers then also deal with the subsequent changes that are coming in. This, I suppose, one of the ways to look at this as well, though, is that actually with the unfair dismissal rights being a day one, a protection of unfair dismissal being a day one right, it means that employers will follow, or hopefully follow, careful processes and procedures more so. But actually it also means that going forwards, if there is any risk of claim, that employers will likely take a more careful approach as well in any decisions that are made. So obviously what this means for employers is that there will be an increased risk of claims, but actually on the flip side, it strengthens the rights and protections of the employees and any subsequent decisions that are made. If we move on now to ending 0 hours contracts. So another change that's proposed by the Labour government is ending 0 hours contracts. As it says on the slide, a 0 hours contract is a type of casual worker contract under which someone is employed without a minimum specified level of guaranteed work or pay. 0 hours contracts also provide those that are on them with, they're not limited as to whether they can work for this one employer as well. So it adds optimum flexibility for the individual if that is their choice of contract. It also means that employers as well have the flexibility to decide to manage shifts for staff, and so they can have as many or as few staff members that they want without having the obligation to offer that work. The government sees 0 hours contracts as exploitative in nature, as there is no obligation on them, on employers to offer work, but there is also no obligation on the employee to accept the work. So it creates a lack of certainty, more so for the employee, but also for the employer that the employee may not accept the work. It's one of those things where as I said, there is a lack of certainty, but as I said earlier, it creates flexibility for both parties involved. And often those that are on a 0 hours contract, it's actually often for them, it's made a decision to them because it could be more beneficial. The government, whilst proposing a ban on these contracts, they're intending that actually instead they introduce a minimum number of hours that have to be offered for doing work under these contracts. So it's rather than a 0 hours contract, it will be a minimum hours contract, is probably the better way to look at it. The proposal is that the minimum number of hours will be based on an average number of hours that are to be worked across a 12-week reference period. That's speculative, it has not been confirmed, but it would fall in line with other reference periods that are used throughout other employment legislation and decisions. The government is also proposing that with these types of contracts, they also provide for reasonable notice of any change in shifts or working time or cancellation of shifts, and that if there is a change or cancellation, that there is compensation is given that is proportionate to the notice given for any shifts cancelled. So essentially, if an employee is on a minimum number of hours a week and their shift is cancelled, the employer must give them notice of that cancellation or change, and there will also be compensation for that, which will likely be a monetary sum. Again, how this will work in practice is not entirely known, especially for employers in certain sectors such as the leisure and hospitality sectors, who often rely on these types of contracts. And a lot of employers may also have staff on their books who work irregular patterns or may only do seasonal or term time work. So if you're working in a city that's got a high student population, you may find that these contracts will be affected quite significantly by this change. The government haven't said that it's their intention that employers can't rely on fixed term contracts. So whilst you may not be able to use a 0 hours contract, you may be then able to use a contract instead that may be just for a short fixed term period in time that will maybe see you through, for example, for a term time for a university student or something like that. What this will, as I've just said, what this will mean for employers is that employers will need to look very carefully at the contracts that they have in place, because this is a new law, and it is the intention that this will provide those on 0 hours contracts with greater protections going forwards. So employers should take this as an opportunity to review their current employment contracts and identify those that are currently on 0 hours contracts and look to see whether there is something that they can maybe looking to put in place now. For example, taking a 12-week reference period and maybe starting to look at some of those average calculations that can be done. Employers may also want to have a look at the processes and procedures that they currently have in place for cancelling shifts, but also managing and offering shifts as well, with a view to considering some of the processes that could be changed, such as notification to an employee and how much notice you currently give and what the expectation may be going forwards. There is also the possibility that this will increase labour costs for employers. because you will not only have to guarantee all staff a certain number of hours per week to work, but if those shifts are changed or cancelled, you may have to pay them some form of compensation in any event. As a result, this could increase this could deter certain individuals from looking for higher levels of flexibility or casual work from entering or continuing to be part of the workforce under these terms of employment. If we look to the right to disconnect now, please. So the right to disconnect is a new proposal by the Labour government. The plan is to introduce legislation that will allow employees the right to switch off out of work. So they do their core hours of work, and then at the end of the day, they can disconnect from work and not feel any obligation to respond to any work calls, emails, or engage with work outside of their hours. It's in a bid to encourage and promote healthy working practices and to bring a greater work-life balance to those that are in work. What this could look like, it's expected that this will replicate current European models, specifically Ireland and Belgium having been mentioned as particular models for this new legislation. France do have a right to disconnect model that's been in place, I think, certainly since 2016, but they haven't been mentioned as a model to look for. It's more Ireland and Belgium because of the way that they currently operate. In Ireland, they have a code of practice which sets out the right to disconnect, and it recognises legitimate situations that may arise where an employee may need to be contacted outside of hours. So the code sets out that the employee has a right to not routinely perform work outside of their normal working hours, the right to not be penalised for disconnecting. So if they don't respond outside of working hours, they can't suffer as a result of that. And a duty to respect another person's right to disconnect. Essentially, if someone else has disconnected from work for the day, they need to respect that person and not get in contact unless they have to. It also sets an obligation on employers and managers to ensure that this is followed as well. So that places a heavier burden on management to make sure that staff are disconnecting, but also there is that respect between staff of those who have disconnected from work for the day. Some of the legitimate situations where contact can be made include those on flexible working arrangements. So if someone's flexible working hours, maybe they work an extra hour or two at the end of the day compared to others, they can connect with others during that time because they are working, but they need to respect that others do not have to respond to them. Global time zones, so working in different time zones, there may be a situation where employees have to respond to someone else working in a different time zone. An organisation's culture in terms of expected response times, as well as the tone and means of communication. For example, if you work in an environment where it is expected that you respond within a certain number of hours, then it may be expected on you that if you have disconnected, you may need to respond. Again, just reinforcing here the role of the managers in implementing and upholding the policy as well. So managers may need to contact people in order to make sure that they are actually following the policy, and also to ensure employees' well-being and health and safety as well. In Belgium, the right is set out in legislation. So rather than it being in a general code, it is a statutory code of practice out in Belgium. However, they have two different processes. For civil servants, they cannot be contacted outside of normal working hours unless in exceptional circumstances. In the private sector, however, employers must have a written document on the right to disconnect, but this only applies to companies with 20 or more employees. In France, it's 50 or more employees where they need to at least try and have a policy. The rules for the policies must include practical arrangements for the right not to be contactable after working hours, and instructions for use of digital tools to guarantee rest periods, holidays, and employees' right to private and family life. So in Ireland, it's more comprehensive, it's very specific, whereas in Belgium, there's a lot more ambiguity. So the expectation is that what we have over here may be a happy medium between the two, but whether it's something that comes in legislation or through a code of practice or guidance, we don't know. But the expectation is that there will be something in legislation just to enshrine that right, and then guidance to go alongside it. What this will mean for employers is that employers will need to carry out reviews of their current policies and procedures in line with the new requirements when they are announced. Employers may actually wish to take this as an opportunity anyway to have a look at current working practices of staff and general policies anyway, just to see whether there's something at the moment that could already be done to encourage and to take a look at employee wellbeing and encourage a work-life balance of employees, and to see if there's anything that can be done to genuinely support employees in maintaining that balance now, before the government imposes the changes on you. It's also a good chance as well to take a look at the workplace culture that you may have already, to identify whether there are any toxic working habits, and maybe to try and stamp some of those out as well. Employers will also need to think carefully about how this will work alongside a flexible workforce, and also look at it in hand with your flexible working policy. You'll need to make sure that there is that separation of work and home life for employees, and that those that maybe work more flexibly do not disrupt that time of other people who may not be working the same hours. A consideration that could be is that the separation is, will companies have to look at the way that they issue company equipment, such as phones and laptops, to ensure that there is separation of work and home through the means of electronic devices, rather than just expecting employees to not respond to any messages or anything that may come through on a personal phone, which is quite hard for people to do. So it's practical. This will be more of a practical consideration for employers that they'll need to consider, as well as alongside the policies. It'll be the practical impact that this may have going forwards. Over to Antonio.
Thanks very much, Lydia. Yes, already from what Lydia has outlined, I think it's fair to say that some of the changes that are there are sort of, well, revolutionary for want of a better word, in terms of the impact that they will have on the workforce, and on the way that people are used to working. Moving on to sort of flexible working, Lydia sort of mentioned there when talking about the right to disconnect, there's going to be a lot of challenges, inevitably, if you start introducing, for example, the right to disconnect, whilst at the same time giving what seems to be hinted at here, a much clearer right and a much clearer emphasis on a flexible workforce, and how those two will marry together will be very interesting to see. I should add, actually, before I go any further forward, I didn't mention this at the start, but if you do have any questions arising from anything that Lydia or I say, please do put them in the chat or in the Q&A. We are hopefully going to have a little bit of time at the end to just pick up on a few questions that people have. But yes, moving on to flexible working, I think it's important to recognise that already there's been some change around flexible working this year, and I suppose if you're going to be politically cynical about it, you can say that both of the governments that we've had in 2024 have recognised a desire stroke need within the workforce, and certainly a popular move amongst voters is one around having greater flexibility in their life and in their working life. So potentially that could be a very understandable reason as to why it's being looked at so prominently and so regularly. So currently, workers have the right to request flexible working arrangements, and employers may reject these applications for established reasons. The right to request flexible working has recently become a day one right, so we're literally talking 4 or 5 months ago, whereas other family-friendly rights generally come in after a particular period of service. The one thing that's important to note is that those changes that occurred a few months ago didn't change the reasons an employer could reject flexible working requests for, and that I think is likely to be a focus of the new government in terms of actually how can they strengthen flexible working rights, because at the end of the day, it's not, as long as there are valid reasons that fit within the recognised criteria for declining a flexible working request at the moment, it's not the hardest thing to do from an employer's perspective. Therefore, I expect that there will be more challenges put in the way of employers from doing that. So strengthening the right to request flexible working is something the Labour government are talking about, and limiting the employer's discretion for refusing those flexibility requests. Again, narrowing it down, moving towards a culture, if you like, a work culture where perhaps in some areas there's almost going to be an expectation that people will work flexibly, whether that's in terms of location or hours, who knows. The further granting of family-friendly rights from day one, and that's looking at including paternity leave, parental leave, parental bereavement leave, shared parental leave, carers leave. Now, those at the moment are all service related entitlements that people have. They don't have them as day one rights. But if you look at it, it does make perfectly good sense for most of those to be day one rights, because we're often talking about maybe not necessarily one-off events in life, but certainly things that don't happen regularly. So when you're thinking of someone taking paternity leave or shared parental leave, there are only limited windows in someone's life where that is relevant to them. So making that available to everyone, regardless of their service, doesn't seem to be too much of a concession, but clearly a big benefit for those that will reap the benefits of it. What will this mean for employers? Well, generally, it will need to be changes to the current flexible working and family-friendly policies that they have in place, tied in with those tweaks that are made to the legislation, and the need to review the position that's adopted in respect of flexible working, because going back to the fact that there are very clear established reasons why flexible working requests can currently be rejected. If we move away from those, many of the rationale and the thinking that employers have followed up until now, if they didn't want to accept a flexible working request, or if they had reason not to, may well be thrown up in the air, and that may need, if you like, a bit of an education piece as to how people should view those going forward. Moving on to the new sexual harassment laws, here we have a slightly different situation in that we have legislation that is now very soon going to be taking effect, that is left over from the last government, that will have an impact, and I think it is important that all employers are aware of this and are taking steps in the next month or so to cater for these changes. But we've also got a situation where, again, similarly to both 0 hours contracts and flexible working, the new government is not happy with what the old government had proposed and is now going to change things further, or potentially going to look at changing things further. So when we're talking about sexual harassment, I'm just turning this slide sort of upside down slightly. Let's think first about what actually is sexual harassment and what does that mean. So sexual harassment is set out in the Equality Act from 2010, defined as unwanted conduct of a sexual nature which has the purpose or effect of violating a person's dignity or creating an intimidating, hostile, degrading, humiliating, or offensive environment. It's important to note that where we are talking about sexual harassment, it does need to be sexual in nature. We're not talking about harassment on the grounds of sex. So saying something that is, for example, degrading based on specifically a person's sex. It has to have a sexual element to it. So examples of this can include sexual comments or jokes, propositions and sexual advances, displaying sexually graphic pictures, posters or photos, and then even more extreme, unwelcome touching, hugging, massaging, etc. Now, what does the current law say? Well, current law says clearly sexual harassment in the workplace is unlawful. Under current laws, employers are liable for their employees' actions that occur during the course of employment. And currently, though, employers only need to show that preventative measures they have implemented. So it's quite a low threshold in terms of expectation. Obviously, employers have a duty to provide a safe working environment, which clearly, if someone is the subject of certain forms of sexual harassment, then that would not be the case. But the actual duty to show what steps they have taken is quite, let's say, wishy-washy at the moment. So what is changing for sure from next month is we have the Worker Protection Act, otherwise known as Amendment to Equality Act 2010 as well. This poses a mandatory requirement on employers to take reasonable steps to prevent sexual harassment in the course of employment. It requires employers to take proactive measures in doing that. And in circumstances where an employer is found to have breached that new duty, successful claims of sexual harassment in the employment tribunal may be uplifted by up to 25% to in essence punish the employer for not having taken things as seriously as they should do and take those reasonable steps to prevent sexual harassment. Now, what does that mean in practice? Well, as a minimum, employers need to make sure of a number of things. First of all, that employees have a clear understanding of harassment and what may go beyond the bounds of acceptable behaviour. Clearly, there's in some working places a blurred line at times. What is banter? What is not banter? What kind of banter is acceptable? Is banter ever acceptable? And all those kinds of questions that throws up. So actually setting out clear guidelines and giving that clear understanding to the workforce as a whole is very important. Making clear what the consequences of engaging in acts of sexual harassment would be. Now that's clearly going to be disciplinary in nature. I think spelling it out and making it clear that acts of sexual harassment potentially amount to gross misconduct, potentially could result in people being dismissed summarily without notice. And in certain environments, when we look at, for example, education, there may be further reporting requirements that need to be made if someone is found to have engaged in acts of sexual harassment. Now, what that means in practice is those are policy related type discussions, if you like. So what does that mean? Does that mean you simply tweak your existing disciplinary policy to reference that sexual harassment might be viewed as gross misconduct? Well, most disciplinary policies will probably make that clear to some extent or other, but you you really need to start thinking now about actually having a separate sexual harassment policy that covers these kinds of things, that covers making sure employees are clear on what sexual harassment means, making sure the consequences and the process that would be followed in circumstances around sexual harassment would be. Providing clear statements of accepted behaviour, including online and at work social events. Now, clearly, we live in a very much an online world. To some extent, people will be communicating with them, whether inside or outside of work, with colleagues, and sort of making sure that behaviours in that work context are maintained and remain appropriate. Clearly, social events, we're going towards Christmas party season. Dare I say it's in September, but those are the kind of events that inevitably, from our perspective, year on year, create a myriad of issues that employers are forced to resolve, and this additional obligation on employers is very clear now. Ensure employees know what to do if they experience or witness sexual harassment. Make sure that they know that there is someone that they can turn to, whether it's their manager, whether it's HR, whether it's particular people in the business who are designated to support these kinds of circumstances. And not only are we talking about people who are the victims of sexual harassment being able to do that, but also anyone who witnesses it, because clearly it's important that everyone feels able to speak out, but also that anyone's concerns are taken seriously, particularly because there may well be circumstances where the victim is not in a place where they themselves want to take things forward. And finally, also ensure that employees and that managers in particular know what to do if sexual harassment is reported to them, and how to progress it, what the system looks like for dealing with it, how things should be escalated, how people should be looked after, and sort of making sure again that there is a safe working environment, and that any sort of risk is dealt with. Now, how do you do that? Well, I think realistically, if you've not been thinking about it already, you really do need to think about, as an employer, having some training around sexual harassment as soon as possible for your employees, to emphasise some of these points we've touched on, to make sure that it's clear what we're talking about, clear what the consequences of that kind of behaviour are, and what potential actions people can take in circumstances where they witness or are involved in that kind of situation. Alongside the training, as I mentioned, I would recommend having a separate policy in place dealing with sexual harassment as a separate standalone issue, so that it's very clear to everyone. You can obviously link the training and the policy together, and use the training to introduce the policy to staff, but otherwise, you do need to make sure that people have given sort of some form of consent, I would say, that they've read and understood any policy that you're implementing, but obviously not treating that specifically as a tick box exercise. You do need to try and keep things as tailored as possible, providing generic training to one environment that may be extremely appropriate, let's say, for an office environment, may be extremely irrelevant to other environments where sort of, for example, individuals are out and about, or working in different ways. So making sure that any information you give staff is as relevant as it can be to them. As I mentioned at the start of this section, this is obviously an area where we have that immediate impact and change that's coming up in October from the prior legislation from last year, but we now have further talk as well of potential further changes. Now, strengthening the law to require all reasonable steps is one potential relevant change rather than simply reasonable steps. If you have to take all reasonable steps, you have to leave no stone unturned, and that places a even stronger emphasis on employers to make sure that they are really doing everything that they can do to ensure that sexual harassment is not taking place in the workplace. So that's interestingly the original wording that was proposed to the act that's now coming in, and it was amended as it went through Parliament. And clearly now there's talk of it going back to its original wording and, as I say, putting more emphasis on employers still. What else could this mean? So employees who report sexual harassment would also be automatically treated the same way as whistleblowers. That's one of the proposals that's in the pipeline. So in essence, treating a report of sexual harassment as whistleblowing. I mean, arguably, depending on the specifics of it, it's almost invariably going to be whistleblowing now, as well as sort of a protected act in terms of protection from victimisation in itself. So I don't know how much more protection that adds, but it certainly highlights the severity and sort of maybe focuses people's minds a bit more on the fact that any action of sexual harassment will be protected and people will be looked after if they raise this. And I think it is appropriate actually at that point to note that many instances of sexual harassment, etc., do relate to situations where there is an imbalance of power, where people are concerned about raising concerns, and you may be raising a concern about a very senior individual in a business, and it is necessary for people to feel safe and able to raise concerns. And the other potential further change was another one that was discussed around the time that the legislation was proposed. If we look back about a year or so, the requirement to protect against third-party sexual harassment. So in particular, customers, members of the public, etc. So if you think of people who are in client or customer facing roles, or people, teachers being a good example, who are very much interacting within their work environment with people who are not necessarily under the control, if you like, or part of the employment structure of the employer. So having an emphasis again on preventing sexual harassment, but this time preventing it from third parties whilst someone is working. Now, again, there's an element of this that you look at the need to provide a safe working environment, etc. There are already obligations to some extent on employers around this, but this will strengthen it. If this type of legislation comes in, then there will need to be much clearer obligations and an understanding of employers in terms of protecting staff. Now, you do get examples. I'm thinking of sort of bars or pubs that might have signs up around bar areas saying that they won't tolerate abuse of staff. Another great example of that is sort of train ticket offices, places like that. The likelihood is you'll see a lot more of that signage. You might even see extra CCTV, extra protection, that kind of thing, to deter individuals who are not employees from doing anything inappropriate around this. So what would these changes mean for employers? Well, again, clearly that would require a further review of policies and procedures in line with those kind of heightened requirements. They'd be expected to have tailored policies in place in respect of their their size, sector, and working environment, so that everything is clear. Potentially internally and externally, because you've got to ensure that any third parties are aware that sexual harassment will not be tolerated, and sort of having those strict rules and consequences to prevent this. As I've mentioned, that you do already find in some environments. So moving on from sexual harassment to potential changes to sick pay. So currently, statutory sick pay applies to all employees and comes into effect on the 4th day of individual sickness absence. Under the proposed changes, the Employment Rights Bill would remove that 3-day waiting period at the start, so that statutory sick pay must be paid from day 1 of sickness rather than day 4. There's also discussion around the removal of the lower earnings limit, so that even very low earners can qualify for sick pay, which they currently don't. The latter, which seems an entirely reasonable thing to be looking at. What this means in practice, well, obviously, most people's contracts, particularly where they don't pay any enhanced company sick pay, will refer to people getting statutory sick pay, and may refer to the fact that they will be unpaid during the first 3 days of absences. So contracts, policies, procedures may well need amendment in the light of these proposed changes. It probably also means an increase in costs for employees where employees are absent, and it may also encourage additional short-term absence. I think it's fair to say that in some working environments, the fact that you are not paid during your first 3 days of absence probably does deter a lot of individuals from taking extra sick time. Clearly not the case in all working environments, but for some it is a clear deterrent, and sort of allowing people to have SSP from day 1 may just see an increase in those shorter term absences. Ending fire and rehire. So where we're talking about fire and rehire, others will know it more as dismissal and re-engagement. So it's been used by employers over the years to implement changes in contractual terms, particularly where employees have been otherwise unwilling to agree to vary the entitlements. So what we're talking about there is typically if you want to implement a change, you might be changing, as many employers have in recent years, changing pension schemes to less generous terms, or removing particular benefits, changing places of work. So usually quite big changes, if you like, that employees will put a bit of resistance towards. The fairly common practice has been to try and reach an agreement, have a consultation with the individuals, but if that agreement can't be reached, of serving contractual notice to them, but immediately offering them re-employment on the alternative terms. It's always been seen as fairly heavy-handed. It does, if you like, illustrate the imbalance of power that there is between employers and employees. I think it's probably the one existing practice and area of law that really does highlight that, I think, to be fair. And even the previous government was very clear. I think even all the way back to sort of Boris Johnson was not happy with the practice and was talking about removing it. And as a consequence of that, we had this new code of practice that was introduced as recently as July, that's stating that the practice should be viewed very much as a last resort, but it may still be used if there has been a thorough and open information sharing and consultation process. That's again one of those areas where the new government has looked at it and thought, well, this isn't good enough, this isn't the level of protection we want people to have. So they have said that they will, in quotes, introduce effective remedies in the Employment Rights Bill. What exactly those are, we're not entirely sure yet. So what one suggestion is that dismissing offering to rehire on new terms will only be allowed as part of a restructuring process where there is genuinely no alternative to keep the employer's operation viable. So in essence, employers won't be able to use it to just make a contractual change that they would like, to cut a bit of cost or to remove let's say a benefit that's particularly troubling to manage, for argument's sake. But it can be used if, for argument's sake, let's take the pension scheme as an example, because it's quite a common one, that were the pension scheme or the pension arrangement not to be changed, then the business would go under, in essence. So in those kind of circumstances, the suggestion is that this dismissal and re-engagement would still potentially be an option. The new government have described the July code as inadequate, so they're not happy with that. And what this in practice means for employers, it probably means, actually, in fairness, I think the best advice to employers really is actually, if you're thinking about making a fairly substantial change to terms and conditions of your employees, particularly if it's involving a larger number, it's probably something what you want to think about doing sooner rather than later. In going forward beyond that, it's there's going to be more consultation involved. There's going to be more need to agree, or probably more need to bargain with employees if you are going to sort of remove a benefit or change a particular practice that you offer some kind of quid pro quo back to them to try and compensate them and try and reach that agreement. And just finally, looking at other areas that are likely to be reformed. So the first one is likely to bring us much more in line with other European jurisdictions. So collective consultation. So that's at the moment where you've got 20 or more employees that are at risk of redundancy at a particular site. You have the need to collectively consult with them. Now, this potential change would be about viewing the business or the organisation as a whole. So, let's say rather than making say 20 people in one retail store redundant, if you were making 20 people across 5 stores redundant, you would still have this collective consultation triggered. How that will operate in practice with very large retailers, for example, we'd have to see. Extend equal pay to cover disabled workers and minority ethnic workers. Now, there's quite a lot of discussion as to whether this is actually necessary. So if someone was being paid less than a comparator who was either not disabled when they are or of a different ethnic group, then arguably now you could quite easily bring that kind of claim under disability discrimination or race discrimination law anyway. And there's a lot of talk actually equal pay in terms of gender also being largely irrelevant, because if you just scrapped that and just allowed people to bring discrimination claims, it would work just as well. So there's an element of this that is questionable as to how necessary it is, but it's clearly something the government are interested in moving forward. Also, ethnicity and disability pay gap reporting for employers with over 250 employees, very similar to gender pay gap reporting requirements that are already in place, but being compelled to issue similar reports in relation to the ethnic diversity of the workforce and where they sit on the pay scales, and also for disabled employees as well. The other change around gender pay gap reporting, potentially also including outsourced workers in that reporting. So if there are particular functions that are outsourced within a business, that they're not excluded from the requirement for reporting, but also have to be included in that. So that may well have an impact on certain larger businesses, let's put it that way. Then again, one of the changes that we had earlier this year in the old government was additional protection around those on maternity leave, and shortly after returning from maternity leave, around protection from redundancy and increasing that. We're now talking about a further increase in protection, and essentially what is a ban on dismissing maternity returners for 6 months after their return from maternity leave. Clearly, there will be some limited circumstances where dismissals would continue to apply. Clearly, it's not a sort of a carte blanche to come back and commit an act of gross misconduct without being having any consequences for that. But it will add protection for people, and I do think, again, from my years of experience, to be honest, that's a period of time where people are really quite vulnerable when they're returning to work, because they've not been in the workforce for that period of time. Employers may have sort of got used to things being done in a different way, or someone else doing some of the tasks that someone was doing, and it does tend to be a time where people can be quite vulnerable. So understandable introducing that type of protection. An extension of the time limit for bringing employment tribunal claims from 3 to 6 months. Now, this is an interesting one, because some talk is that this will actually reduce employment tribunal claims. Lydia was mentioning earlier that there are, particularly when you look at day one unfair dismissal, there is a risk that could have a real spike and a real impact on employment tribunal claims at a time when the employment tribunals and ACAS are both creaking under the weight of what is expected of them. This potential move, one comment I've seen is that it will encourage people to resolve claims before they enter into the tribunal system. Yes, I suppose there is a bit of scope for that, but that's kind of what ACAS pre-claim conciliation has been put in place to do. Whether it's materially going to reduce the number of claims that go into this system, I'm not sure it will. I think it'll actually have the opposite effect, that more people may well bring claims, and particularly looking forward to times when the job market may not be as it is now, where people are able to go into new roles very quickly and with minimal financial loss. Then it's it may well not be the case that having a longer period for people to issue claims will actually result in claims falling, but it may actually result in claim numbers increasing. And then the establishment of a Fair Work agency with powers to inspect workplaces and take action. the talk around this agency is it will have fairly wide-reaching powers to look at whether things like holiday pay, working hours, things like that are being applied correctly, and consequences for those that don't do that. I'm conscious of time, and I see that there are a couple of questions up that I will have a look at the moment. But just to briefly summarise, I mean, I think we are looking at, as I say, fairly revolutionary changes to the system, and the way people work, and the rights that people will have if all of this comes to pass. And that is, we are at day 75. We're not quite at day 100. When the government suggested that a lot of this legislation would start being put forward. What I'm thinking is we'll probably review the situation perhaps in another 75 days to see where we've got to then. But clearly, for me, my concern would be at this moment in time, yes, great, let's give people additional rights, let's give people additional protection, let's try and encourage, we have a labour workforce deficit at the moment. Let's encourage people back into work, but let's be careful about the burden that we're putting on institutions like the Employment Tribunal on ACAS, because it's all well and good introducing lots of protection for people. If they can't enforce that protection, then it doesn't even serve its purpose, and potentially is just creating headaches for employers, as well as not giving employees adequate ways of enforcing those rights. But hopefully we will see more in time to come, and more encouraging signs around that. Just to make you aware, very briefly, we are offering a contract and policy review, special offer, if you like, linked into the changes that are happening. What we're suggesting at the moment, clearly, a lot of this legislation is up in the air. We can't really say to people, let's update your handbooks and policies in line of it now, because it's not really the right time to do it, because we're waiting to see what legislation says, etc. But what you could be doing now is just having a careful look at the areas within your business that might be affected from these changes, because in all likelihood these types of changes will happen. So knowing where your weak spots are, and the areas you might need to work on, it could well be beneficial now. So we're offering a discounted fixed fee there for people to have a review, and provide them with a report of areas to focus on. And then that will then lead to a discount if you then ask us to do a contract and handbook review for you. I'll just have a look at the questions we've had. Just loading up for me. First question was, can we access these slides after the webinar? Yes, I will make sure that those are circulated. So since the use of 0 hours contracts will remain when agreed by both parties, is there any indication that the length of time a worker employees on a 0 hours contract will become limited? Not really at the moment. It's one of these areas where it seems to change slightly what the government's saying from interview to interview on the news. I think it's important that we recognise that there will be some change to 0 hours contracts. What we do need to be careful of going forward is actually what that will be in practice, and that's where sort of keeping eyes and ears open. And as I say, I think we will have follow on seminars in the weeks and months to come, as the legislation starts coming through. But for now, I think the main message on 0 hours contracts is there may well be changes if you're regularly using 0 hours contracts with your employees, or your workers. You are likely to need to think about how that could be done differently if you need to do that. Okay. I, again, conscious of time, and I think we will leave things there. Thank you all for your time today, and thank you for joining us. I hope you found the session useful. We'll sort of send some follow up and the slides out to everyone, and hopefully we'll see you again on a further update shortly. Thanks very much.